Yes. I was just reading this pamphlet about invalidating a judgment for fraud and the significance of Federal Rule 60B, Poach, by W. Dean Wagner. Yes. When it can be proved that a judgment of a court was obtained by fraud, the question arises whether or not it can be set aside and a new trial had. The problem to be discussed here is when can relief be obtained? Two different procedures are to be distinguished. A motion in the court that rendered the judgment, an independent action to set the judgment aside brought in the same court or different court. Our concern here is with independent action of this kind brought in the federal courts. Federal Rule 60 was amended radically in 1946, altering considerably the formal rule regarding the setting aside of judgments. The new rule, as far as pertinent, provides fraud, etc. On motion upon such terms as are just, the court may relieve a party of his legal representative from a final judgment, order, or proceeding for the following reason. Fraud, where heretofore denominated intrinsic or extrinsic. The motion shall be made not more than 1 year after the judgment, order, or proceeding was entered or taken. This rule does not limit the power of a court to entertain an independent action or to set aside a judgment for fraud upon the court. The rule thus expressly provides that either intrinsic or extrinsic fraud will constitute ground for upsetting a judgment if a motion is made within 1 year, but whether not only extrinsic but also intrinsic fraud will constitute sufficient ground for upsetting a judgment after the expiration of the year period is uncertain. The plain language of the rule seems to give carte blanche authority to a court to grant relief at any time for any type of fraud. Oh, look at that. But recent judicial interpretations of the rule point out questions that deserve consideration. Yes. Now, I know fraud on the court as a word of art was new nomenclature introduced in the 1946 amendment of Federal 60 because of the definitive reference to Hazel Atlas Glass Company versus Hartford Empire Company. An example, imperative for understanding of the meaning of the phrase fraud on the court. Now, I know, okay, The amendment makes fraud an express ground for relief by motion under the saving clause. The saving clause may be urged as a ground for relief by independent action insofar as established doctrine permits. Now, there is a big concern that the court doesn't understand what is fraud upon the court. Within the did the framers, oh my gosh, independent action, Now let's see, every oath of office, you're elected to office. Now this fraud on the court that's causing a fraud of the state where you decided to issue court orders where I was. Well, why doesn't somebody do an independent action? Is there a Supreme Court anywhere in the United States? Now I'm going to sue every attorney oath, every oath of office, all the mandatory reporters that thought, well, I don't have to be involved. Well, if you know of the crime, you're going to prison. Okay. Now today, I'm going to want my sons, all right? And I don't want to have to sleep in a place where I need to do some painting. Oh, do you understand that? Because I will imprison every judge of this nation for being complicit in, accessories to, or enabling any scheme, maneuver, or fraud because of the use of forgeries. Because of the use of the fraudulent court seal. For the arrest that I've had to endure because this court right now. Because I got